and that if we're going to accept that sort of captivity by domination, then we should certainly, and give it and make it a form of self-defense, we should also make actual physical captivity the basis for self-defense. But I think that would be a very interesting question, or at least part of a question, and I have not done any research on whether there are cases of that kind out there. I think there's maybe a good reason for that, which is, let's say you have a real situation, which you have a Silence of the Lambs type situation, right? That's what, she was being held, the senator's daughter was being held captive. I cannot imagine the prosecutor who would bring those charges against the captive who escapes by killing the kidnapper, right? I mean, I guess it could happen if the prosecutor just didn't believe it. If the prosecutor believed that the defendant was making up the story of captivity. But let's assume that that's what we actually have, and the prosecutor believes it. I just don't think prosecutors bring those cases. So I'm not sure you'd ever see it to test that theory. But that's what law school hypos are about. The things that never happen in real life, but you get to write about them in a hypo. Some of you maybe take some solace from the fact that last night I had to answer a law school hypo. Now I saw it in advance, so it was a little of cheating. But I did a panel at the Brandeis Inns of Court, which I'm not going to get into the details of what that is, but it's a group for lawyers in town plus law students. They meet every so often. And last night the panel was on obstruction of justice, and they gave us a hypo that we had to discuss how the law would apply, how a lawyer would handle this case, that kind of thing. And I could not help but feel like I was being put back in law school and having to answer an actual hypo with all the outlandish facts that come along with it. And fortunately, A, I didn't have to do it alone. We have to do it on an exam. And B, I had several weeks to look at it and think about it. So it wasn't quite the same. But still, it reminded me. Okay? Anything else about this? I want to transition using this part to Getz. And we will sort of see how this idea from Leinholm and the Bader-Rubin syndrome cases translates into, or may have some other angles to it in the Getz case. So what happened in December of 1984 in Manhattan? Mr. Webb.
So Mr. Is it Gates or Getz?
It's Getz.
So Mr. Getz was traveling on a subway and was approached by 4 young teenagers.
Well, first tell me about these 4. Canty, KB, Ramseur, and Allen. They were on the train first, right?
They were on the train. They were riding together on the train. They had screwdrivers, and they were trying to break into the coin boxes of video machines.
That's where they were on their way to. And they had gotten on the train in the Bronx, headed into Manhattan, i.e. south down into Manhattan. And Getz gets in the train fairly far south into Manhattan at 14th Street. And unfortunately for all concerned, he gets on the same car as these 4 young men. They had a screwdriver, and he had
a .38 caliber pistol.
And then what happened?
So one of them, Canty, comes up to Getz and asks him, possibly with Allen with him, tells him, doesn't really ask him, says, "Give me $5."
And were they armed as far as
they
he
were
knew?
Sorry?
Were they brandishing any weapon or?
No.
No.
Screwdrivers, but doesn't say anything about them showing him that or making any threats, just says, "Give me $5."
So how did Getz respond? Did he give him $5?
He stood up and shot them in rapid succession.
He fires 4 shots. First hits Canty in the chest. Then the second strikes Allen in the back. The third goes through Ramseur's arms into his left side. He fires the 4th one at KB, but misses. Then what does he do?
So then he kind of surveys and looks for the kid he missed, and then shoots one while they're standing, looking away from him, trying to avoid his detection.
And what does that bullet do?
It goes through his spine and severs his spinal cord, paralyzing him.
Okay, so chaos ensues. The conductor stops the train, and he races back to this car. And what does he see?
He sees Getz is left. He jumps between the cars and then escapes through the subway, I guess through like a sewage system, and gets out.
Well, he leaves not quite. He's not there. He doesn't leave before the conductor gets there, because Getz tells the conductor, "The 4 youths had tried to rob me." Then he flees the scene, as you described. Okay. What happens?
Getz is on the run for 9 days until he's found in New Hampshire, where he turns himself into police.
And what does he do once he turns himself into police?
He talks about.
He talks.
Yeah.
Just stop right there. Okay? You're the lawyer for Bernie Getz. You see these statements. Let's say you don't get to be his lawyer until after he gives these statements. What is your reaction? Give me one word reactions that you have once you see these statements.
Recusal.
Recusal. No, you're stuck. You're stuck, Mr. Smith. What's a one-word reaction that you have to these statements?
Miranda? Plea?
I'm sorry?
Plea?
Plea, okay.
Stupid?
What was that?
Stupid?
Okay, I thought you said he's stupid. That's 2 words. Okay, stupid.
Cursing?
You curse. Okay, this is one of the great examples in American criminal law of how damaging it at least should have been and can be to give statements. That is why every defense lawyer will tell you that the very first thing they ever say to a client is you never talk to the police or whomever, investigators, FBI, whatever, right? Because if you do, you will say things that can be enormously damaging to your defense. Okay, let's work through what Getz says that is so incredibly, powerfully incriminating. What does the statement say?
So he says essentially that he wasn't threatened by the words or actions of Canty. He says Canty comes up and says, "How are you?" Getz is fine. And then they walk over and stood to the left and kind of just like looked at him, and Canty said, "Give me $5. And then Getz says he knew from the smile on Canty's face that they wanted to play with him, and so.
And then what did he say? What's the next thing that he said?
Established a pattern of killing them, so he.
No, go back. What does he say, Ms. Lineweaver?
He was certain that none of them had a gun.
He was certain that none of them had a gun. Okay, you're a prosecutor, Ms. Lineweaver. What do you do with that statement by Getz?
I run with it.
How?
Prove that he had the intent and the want to hurt.
No, really use it in a way that goes specifically, Ms. Wagner.
Prove that his use of deadly force was not reasonable in the circumstances.
And what belief does it show he had or didn't have?
That he was in danger of serious bodily injury or death.
Because he just said, I knew. I didn't just doubt. I knew they weren't carrying a gun. Right? Certainly, at the very least, that closes off one avenue through which the defense could say he suspected they might be armed. He suspected they might shoot him. Well, he said to the contrary. Right? This gives you powerful, no pun intended, ammunition as the prosecution to begin to chip away at any possible claim of what he believed and that he was acting in self-defense. Well, he said something about the gun, Mr. Webb, that he possessed. What did he say about the gun?
He says he was a pattern of fire.
No, about his ownership of the gun, Mr. Razor.
He bought it because.
Oh, he bought it illegally after he got mugged.
And what had happened?
And then he used it twice to scare off potential muggers.
What, you left something out of that. He had used it.
Successfully,
Mr. Wiseman?
All he had to do was display it.
He had used it successfully to ward off threats without shooting. If I'm the prosecutor, I'm going to say, look, Mr. Getz, in his own experience, was that all he needed to do was brandish this gun, and he was safe. His own experience should have told him that this use of force was not what? Necessary. I use that in his statement against him. Right? I want you to always think how can I, anything in the facts, how can I use that little tidbit in a way that helps to do what I need to do to win my case? And these are giving you those little tidbits. And think about how they are best used. That's really important to successful lawyering. Okay? What did he say his intent was, Mr. Webb? Let's take another example.
He said to kill them, to cause as much pain as he could.
Does that sound like self-defense?
No.
That sounds like a very different intent than, what would you say, if you were acting in self-defense, what would you say your intent was?
Incapacitate the other person.
No, I don't think that was your intent if it's self-defense. What's the basic intent of self-defense?
Save yourself.
To protect yourself. It's not to make people suffer, to hurt them, as he puts it, right? Okay? So that's inconsistent with the claim that what he was really thinking was, I needed to protect myself. It's not about making somebody suffer, to hurt them as much as possible. He's again undermined his own claim. Okay? 3 of them reacted by doing what?
Running away.
Running away. What does that show?
They were no longer a threat.
They were not a threat when he shot them. Right? Let's say, even if you agree, ladies and gentlemen of the jury, that at one point, the point at which he was approached and asked for money, they did pose a threat. Let's assume you believe that. At some point during which he was still shooting, that threat had ended. And yet he kept shooting. Okay? Getz said, I said, you seem to be all right. Here's another. He said, if I was a little more under self-control, I would have put the barrel against his forehead and fired. If you were under more self-control, somebody who's actually acting in self-defense, what would you think you would do?
Put the gun away.
Put the gun away. But he says, if I'd been under more self-control, I'd have acted in a more bloodthirsty way. This is not self-defense in any sense I have ever understood it. He said, if I had more bullets, I would have shot them again and again and again. Okay? That's our facts. Does not sound like self-defense to me, but if we're going to make that decision, we need to know what New York penal law says is self-defense. So what does the New York Code say about justification, and when does it permit the use of force?
That a person may use physical force upon another person when and to the extent he reasonably believes such to be necessary to defend himself, or a third person from what he reasonably believes to be the use or imminent use of unlawful physical force. That's it.
And what about deadly physical force?
Okay. And on
Anything
deadly-
more there?
Yes, a person may not use deadly physical force upon another person, unless he reasonably believes that the other person is using or about to use deadly physical force. Or the other person is committing or attempting to commit kidnapping, forcible rape, forcible sodomy, or robbery.
And those last 2 words gets his shot. Right? Because it says robbery. So you can say, they were going to rob me so I could use deadly physical force in response. If New York hadn't added that, and we've seen different states have different triggers for deadly physical force. That is what you are facing. Some just say death or serious bodily injury. Some say death, serious bodily injury, or rape. New York says robbery. And that gives him at least a chance to argue that's what I face. Notice that New York, unlike the model penal code, is all or nothing. If you must have a reasonable belief, and if you don't have a reasonable belief, you lose your self-defense claim. Whereas the model penal code says, if you have a reasonable belief, you win, and if you have an unreasonable belief, it can be mitigated down. New York's like, you better be reasonable, or don't come crying to us. Okay, so the grand jury had some questions during the time that Getz was being brought up for indictment. What happened in the grand jury, Mr. Webb, that leads to this decision?
It was, they asked him, like, what happened, like, what was it reasonable to him as an individual?
And they asked about what the term reasonably believes means within the meaning of this statute. What did the prosecutors say to the grand jury?
The prosecutors wanted it to be like an objective, reasonable belief. So we go back to
The Getz prosecutors tell the grand jury that it must be objectively reasonable. Objectively reasonable. There's a little bit of subjectivity tossed in because the prosecution said whether his conduct was that of a reasonable man in the defendant's situation. So it's mostly objective, but a little bit of in the defendant's situation, which invites the jury to consider it from Getz's point of view on that subway train. But it doesn't go into any details. Look at his past experiences, etc. Right? It's mostly a reasonable test. What did the appellate division, the intermediate appellate court, say about that instruction?
They said it should be subjective because the way it's worded, it says reasonable to him, and they kind of relied on that as opposed to like a reasonable man or reasonable actions. It says reasonable to him, so they kind of took that phrase to mean it was subjective.
And they say it must be, therefore, a subjective reasonableness, right? The only appropriate test is whether his beliefs and reactions were reasonable to him, right? So if he had a deathly fear of Martians invading the planet because he'd seen War of the Worlds, and he thought these four were Martians and shot them, that would seem entirely reasonable to him. How many think that should be the law of self-defense? How many people would feel safe if that from others who might have those kinds of beliefs if that were the law of self-defense? What does the New York Court of Appeals, which is the New York Supreme Court, what does the New York Court of Appeals think of this?
It thinks it's a terrible idea because I think the best quote was to completely exonerate such an individual, no matter how aberrational or bizarre his thought patterns would allow citizens to set their own standards for the permissible use of force.
And would make everyone a law unto themselves. So Judge Wachtler says, no, we have to have at least an objective element of any provision authorizing the deadly use of force. So he says, no, we're going to reinstate this indictment, and Getz will have to stand trial. Okay? All's well that ends well. Right? How many of you had ever heard before you read this case or came into class today of Bernie Getz? Oh, this makes me feel so old. Let me tell you a little bit about Bernie Getz. Bernie Getz had a nickname. Anybody know his nickname at the time this case came up?
The Subway Vigilante.
The Subway Vigilante. He became a folk hero in many circles. And what happened at trial?
He got acquitted by a mostly white jury, and half of the jurors had experienced mugging in the past.
And he did get convicted of the gun charge.
The one gun charge he
The
served.
one gun charge, and that was it. Otherwise acquitted. Although the indictment is reinstated, he gets acquitted. Now there's lots of lessons or things to talk about based on the fact that Bernard Getz was acquitted of these charges, despite all of that evidence from his own statement that his acts were not in self-defense, that they were those of a crazed killer. My own view is he would have had a much better insanity defense based on his statement than he possibly could have had a self-defense claim. But he wins, and he wins for several reasons. One is the New York subways in the 1980s were dangerous. And people, at least those people who got on this jury, could put themselves much more into Bernard Getz's shoes and perceive themselves as threatened and think, how would I respond? I'm glad somebody finally did what I would like to do. and then they could put themselves in the shoes of the people he shot. Another reason they could put themselves more into the shoes of Bernard Goetz than of the people he shot was, what did you say about that jury again?
They were mostly white. And
Mostly
the
white.
The 4 teams were black.
They were white, as was Goetz. The shooting victims were black. And I want to take us all the way back to this reasonableness. What is reasonable in our society? How does the law respond to the argument that, hey, it's reasonable to be afraid of 4 black teenagers? They're threatening. They are a menace to society. So it's reasonable. And it's certainly typical. It's certainly typical, common, that a lot of people have those fears, react that way to young black men. Should what is typical be what is reasonable? What instruction would you give the jury if the prosecution asked, what instruction would you give to the jury if the prosecution asked for a specific instruction saying, ladies and gentlemen of the jury, in deciding what is a reasonable belief, you must put aside any element of race or consideration of the race of Mr. Goetz, of the defendant, or of his victims? Anyone?
Maybe instead say like, as you know that individual versus like, as you view.
You think the defense is gonna, in subtle ways and perhaps overt, call attention to the race of Canty, KB, Allen, and Ramseur? Because they want the jury to be thinking and act on whatever fears and or prejudices they might have. If we allow reasonableness to be the test, in much of our society, in 1984 and in 2018, it is seen as reasonable to be racist. So racism ends up infecting the criminal justice system through the door of judgments about what is reasonable.
Could the prosecution had asked that the race of the victims not be brought in? Like, could they have asked?
And do they not testify then?
No, they could
Are there not going to be pictures of the crime scene? You're going to make the defendant not testify about what informed his belief? What if Goetz gets on the stand? He didn't. But what if Goetz gets on the stand and says, I was afraid of them because they were black? At least in part. It's not practical. It's not practical. Maybe you then get a curative instruction from the judge, but maybe you don't. Maybe you don't. Just as, remember we talked about how if you make the results of the crime, the consequences of a crime, like attempt, if you make that relevant to culpability, you bring dumb luck into the system, right? Because you may have no control over whether or not you hit your target, or the target may duck at just the right, or from your point of view, wrong moment, right? And therefore you've done no harm, whereas the person who's a little less lucky hits their target and they're charged with murder, right? Dumb luck. If you allow reasonableness in a society in which race continues to be a huge factor in how people are treated and how people are perceived, then that can allow jurors to bring their prejudices with them into their decisions.
Was this case when he was ultimately acquitted, was that trial, did that occur before or after Batson v. Kentucky?
Before, after what?
Batson v. Kentucky. I have concerns about
long before.
That would
Long
explain
before.
part.
And it's sort of a reverse situation. because Batson involves situations in which the prosecution is alleged to have excluded black jurors. Here, the prosecution presumably, if the prosecution is thinking in a race-conscious way, is going to want minority jurors. So it's kind of the reverse. Who do you think excluded jurors of color from the Getz jury? The defense. And if you don't think that race enters into these cases, think about how you as a lawyer for Bernard Getz would have treated jury selection. And whether you would have thought that it was to your client's advantage to have a predominantly, or better yet, all-white jury. If you acknowledge to yourself that it would have, you are acknowledging that race makes a difference. Ask yourself this question. If the race of these people had been reversed, if Bernard Getz had been a black man on the subway and he had shot 4 white youths, what do you think the verdict would have been? If you think that the verdict would have been the same, you and I have a pretty fundamental disconnect on the place of race in our society. Ms. Fields, is that your hand?
No.
Oh, okay. But,
Could the defense not have argued that the jury selection was like discriminatory?
the defense?
Or the prosecution?
The prosecution is in a difficult spot here. Because the prosecution, if they say there has to be minority representation on the jury, and it was not an all-white jury, by the way, but it was a predominantly white jury. If the prosecution says, we want African Americans on this jury, they are acknowledging the racial dimension of this case. So it's difficult. I mean, they're certainly going to refrain from exercising the peremptory challenges in a way that excludes African Americans. But remember, there is a fundamental truth of life in America for African Americans, Hispanics, etc. Right? What term do we use for groups? Minorities. Right? When you are the minority, it means that it is much easier to exclude you from juries. Right? Because there are going to be, by almost in every situation, except in few places, you're going to be relatively fewer of you in the jury pool. Right? Let's say you have a jury pool of 50 in the veneer. African Americans in this country are about 10% of the population?
Yeah, probably, or 11, yeah, 10.
I'm sorry?
Yeah, I said 10 or 11.
10 or 11. So there's going to be how many, if we're assuming it plays through? 5. And how many whites are there going to be? Because there's also going to be some Hispanics and others, but how many whites approximately?
42.
About 35. If there are 35 white people in the veneer, and you are looking at this through a racial lens, you only have so many peremptories. You can use those peremptories to strike 5, but you sure can't use them on 35. These people are going to get through, these people are not. So it is in the nature of the numbers alone. Now, in some parts of the country, those numbers are different. Some communities, some cities, they're different. And it becomes harder to eliminate all African Americans from the jury. But it's still going to be easier. Just when you're a minority, that's what can happen. That's what does happen. I want to use this discussion to talk about stand your ground. Although Getz was not a stand your ground case, it came long before stand your ground. If you look at the KRS, you will find that there are 3. If you're looking for it, you're like, I don't see the word stand your ground in the KRS. Well, they don't use that terminology. What they do is something like you see in 3 sections, 503.050, 070, and 080. 503.050, 070, and 080. and I'll just use 050 as an example, but the language is very similar in the other two provisions as well. That is use of physical force and self-protection, the basic self-defense provision. Subsection 4 of 503.050, subsection 4, says, a person does not have a duty to retreat prior to the use of deadly physical force. The traditional law on duty to retreat had been that, well, several facets. One is you did not have a duty to retreat unless you could do so knowing, not just believing, but knowing that you could do so with complete safety. That was the traditional law. You had to retreat if you knew you could do so in or with complete safety. Now that's a pretty high bar for the prosecution. Prosecution has to show, in order to say you had a duty to retreat so you couldn't use physical or deadly physical force, this defendant knew under those circumstances that he or she could retreat with no risk at all. Right? So if the defense can convince the jury that there was at least some risk if they retreated, then they didn't have a duty to retreat, and the jury should find for the defense. Okay? So that was the traditional law. There was a duty to retreat, but boy, only in really limited circumstances, that you knew you could retreat with complete safety. And you also had no duty to retreat in your own home at all. That's the Castle Doctrine. The Castle Doctrine. No duty to retreat in your own home. In 2005, I think, or 2004, Florida began the Stand Your Ground movement, passing legislation that essentially eliminated the duty to retreat. So, in other words, saying, even if you knew you could do so in complete safety, you don't have to. You don't have to. You can stand your ground. Okay? That's what stand your ground laws are. That's what they do. They repeal the duty to retreat. Now, these are policy questions. You can certainly think that's a good idea, that we should have no duty to retreat at all. My own view of this is that this is an entirely reasonable proposition for the law to take. That before you shoot somebody, before you kill somebody, before you use deadly force, that we should require that you do this if this is true. Only if it's true. Right? We're not going to require much of you, but if you know you can, there's an alternative that you can retreat with complete safety, you ought to do it. And if the prosecution can show this, then you should not be able to avail yourself of self-defense. But 31 states, at least as of 2013, I think it's more now, had enacted stand your ground laws. Now, why does this connect to Bernard Goetz in that case? Because the data shows conclusively that there is an enormous racial disparity under stand your ground laws. Okay, let me talk a little bit about that. Okay? Well, first, let me tell you about a couple of things. First, in stand your ground states, homicides that were found to be justifiable rose 8%. Okay, putting race aside, rose significantly in those states compared to non-stand your ground states. So we're finding there are more killings and more of them are found to be justifiable. So maybe you think that's a good thing if you think that people ought to be able to protect themselves. Maybe you think that's a bad thing because more people are dead. Okay? In states with stand your ground laws, the shooting of a black person by a white person is found justifiable 17% of the time. Okay? While the shooting of a white person by a black person is deemed justifiable, anybody want to guess the percentages?
0.
1.
It's not 0, 1% of the time. a pretty significant disparity. Okay? Remember I said that these is in stand your ground states. Shooting of a black person by a white person is found justifiable 17% of the time. In non-stand your ground states, such killings are found justifiable 9% of the time. Right? So stand your ground laws make it more acceptable, at least in the minds of prosecutors and or fact finders, to excuse situations in which a black person shoots a white person. In which a white person shoots a black person. Okay, there is a racial dimension to the repeal of these laws that allow people acting in situations of inter or cross-racial violence to not be held responsible.
Did you say that that in Kentucky is a stand your ground?
Yes.
Okay.
KRS 503.050 subsection 4, KRS 503.070 subsection 3, and KRS 503.080 subsection 3 all say no duty to retreat in various situations.
What was their I guess you said it was Florida who
Florida started
started
this.
it? Why did they eliminate
Why?
the retreat?
Let's play hangman. Maybe you like to play hangman as a kid?
I still play it.
Somebody say no?
Yeah.
Oh, you do? Okay.
No, I don't.
This is the easiest game of hangman ever. And I want to say before I play this game of hangman that I'm not going to make a political judgment about this. These laws, maybe these are justifiable homicides. And the law didn't recognize them before, and now they should. Now the racial part of it, I think everyone should reckon with. But that may be about the underlying racism of our criminal justice system more than it is about the stand your ground laws in particular. But here's the game. A 3-letter hangman. It's the easiest hangman ever.
What?
Anyone want to give me a letter?
E.
E? E is not correct.
N.
What?
Yes.
N is correct.
R.
Yeah? A. And I'm not kidding. The impetus for these laws was the NRA. The NRA pushed this, drafted them initially, and has been enormously successful in lobbying for them in other states. That's your answer. And the NRA is a powerful political interest group, right? And intrinsically, there's nothing wrong with that. I personally disagree with a lot of their goals, but that's how our system's supposed to work. You organize and you push for the goals you believe in and try to make sure that legislators understand that you have a lot of voters behind you, and that's how it's supposed to work. And if you disagree with the NRA's goals, then the proper response is to organize better and organize more people and change policy to the best you can. But there you go. That's the true answer.
Is it possible that some of the reasoning for these laws was to, not subject people who had been in what was considered a justifiable shooting to some of the criminal process?
Sure. Yeah. The idea is that, if you think that imposing any duty to retreat, because we're assuming you're in a situation in which you face the threat to begin with, because otherwise you wouldn't have self-defense as even a possibility. And the idea is that once you face that threat, the law shouldn't impose any duty on you. There is an element here of an assertion of masculinity. It's unmanly to run, right? If somebody threatens you, you take action. And that action is not turning tail and running. That action, so we should not impose a duty to do that which is wrong, or at least not required. Somebody chooses to run and hide, then they can, but the law shouldn't tell them they have to. I think there's a lot of elements there. And if they choose not to, the law, they shouldn't get caught up in the law. And one of the, in a lot of these stand your ground laws, including Kentucky's, there is immunity from prosecution. It's not just that it goes from the fact finder, but first there has to be a determination, which you can, as the defendant, appeal, that you are not even subject to prosecution. And if you get that immunity, you're not subject to the criminal process at all, right? So you have this preliminary process that can get you around a trial where the fact finder decides, because there's no duty to retreat, so you're good.
Going back to Getz, the New York penal law, do you think that they included robbery because they were trying to deter robberies from happening? Or that they saw that it was such a problem because they had so many robberies that they
I think I mean, I don't know the answer to that, but I suspect they included robberies because robberies often involve situations in which there is a deadly threat. Now, could they have been a lot more careful in limiting it? Maybe they could have limited it to armed robbery. Maybe they could have put more detail into the circumstances so that it's not just any robbery. But I suspect that was the impetus, was because it was seen as a particularly serious crime presenting a particularly serious risk to which deadly force might be an appropriate response.
And going back to the duty to retreat, when they were promoting this in Florida, was it supposed to deter people from getting in these kind of interactions? Because to me, I feel like it encourages people to carry guns, just like waiting for the time that they get to shoot somebody for entering their space. Like, I feel like people like Getz, he was carrying the gun around, waiting for the time that he could shoot someone.
It's hard to say whether stand your ground laws alone are any sort of an incentive or a significant incentive to be armed. They may give people, they may make people feel like there's more reason to be armed, and so it could be that. But what we do see in the data is that there is a huge correlation between states that have statutes that give people the right to carry, either open carry or concealed carry, and states that have stand your ground laws. So when you put those two together, we are giving you the right to carry, sometimes both, open, sometimes and concealed, sometimes one or the other. And we tell you, if you do have a gun on you, you can use it when you perceive yourself to be threatened. That is a combination that leads to more shootings and leads to more people being armed. But it's hard to isolate stand your ground in that, apart from the combination with carry laws.
I'm sure it varies probably state to state, but in the stand your ground law, is there no restrictions on how you can respond to what you perceive?
Not a restriction that involves having to retreat. There is still let's say there's still a requirement that you have faced the kind of threat that the state requires you to face. There's still a requirement that you have a reasonable belief that you were threatened, but the prosecution can't say, and as an element, even if you could have otherwise used deadly force, you couldn't in this case because you could have retreated with absolute safety. That's what's taken out of the picture. But yeah, it's still possible for a prosecution to answer and seek to overcome a self-defense claim, just not based on the idea that, hey, there was no necessity because you could have retreated with complete safety. Remember, the duty to retreat is where it exists and when it used to exist universally, is a lot like, or at least it's related to imminence, because they both tie into this idea of necessity. If the threat wasn't imminent, using deadly force or force wasn't necessary. If you could have retreated with complete safety, then it wasn't necessary to use physical force. It all comes back to this concept of self-defense is a law of necessity. Stand your ground makes it less so. Okay. Let's talk about Ceballos. Ceballos lives alone in San Anselmo, California. He ordinarily lived above the garage, but sometimes slept in the garage because why not? Right? You got a garage, you may as well put it to good use. And he kept about $2,000 worth of property there. In March of 1970, tools were stolen from his home. And in May, he noticed that the lock on his garage doors were bent, and the pry marks were on one of the doors. These are telltale signs that somebody is at least trying to get in, maybe to rob you, maybe to do you harm if you happen to be home. So he is concerned. And in his concern, what does Ceballos do about it?
He sets up a trap gun that will shoot if the garage.
He does what?
Sets up a trap gun.
That doesn't sound like a good idea. At least sounds like an awfully dangerous one. So how does this work?
So if someone succeeds in opening the door, it must pull some kind of lever that then fires the gun directly at where the door is open.
And this happens, how does this happen? Sounds pretty automatic.
Yes, it's like a machine that's set up so that nobody has to be there to fire the gun.
Nobody has to be there. And when somebody is there, they can make a decision. Is this a good idea? Is this truly necessary? As you say, a trap gun makes no decision. It reacts simply to the physical moving of the door. Okay? So if the door is open just a little bit, this gun will go off. So he says this was designed to keep a burglar out of my house. He wanted to protect the property. He didn't want to come home again some night and see if have a thief in there. That thief might have a weapon. So it didn't take long, did it? What happened on May the 15th? Or is it May 13th?
May 15th.
May 15th. What happened on May 15th? Mm-hmm.
So two boys, teenagers, were able to open the door, and one of them was shot directly in the face by the
This is Stephen and Robert, a 16 and a 15-year-old, obviously doing something they shouldn't have been doing.
Yes.
And apparently they had also been the ones who originally damaged the lock. They were not armed at the time. And he, Stephen, is hit in the face with a bullet from the pistol. He said, look, I was there to steal some musical equipment because I have a debt I wanted to repay, but I wasn't sure if I would have actually gone through it once he got there. I want to assume he was going to do it. Stephen and Robert were going to steal the Ceballos' stuff. Okay? So what is Ceballos' justification argument here?
He was trying to protect his property from being stolen. He didn't have much property, and then he had a right to protect his home.
And he's saying, if I had been there, I would have been justified in shooting Stephen because he's trying to commit burglary. That is, Stephen is trying to commit burglary. So he had a right to do, he says, indirectly, what he could have done directly. So, therefore, I have not done anything wrong. I have not done anything wrong. The government says, hold on a second. Using a gun like this constitutes excessive force and these circumstances don't justify the use of deadly force. What's the answer?
No, you cannot do that. And some of the reasons that they give are because there's no decision that can be made, so you can't determine if there's actually an imminent threat and it imperils lives of children and firemen and policemen and things like that. So
So there's a
not
qualitative
justified.
difference, not just a nuanced difference, a qualitative difference between deciding on the spot, oh, this is a action I am justified in taking, and having something that will act automatically in all situations when you're not there that might shoot somebody. Like, I think we would all agree that we would not, if our house was on fire, or even if it wasn't, but a firefighter just thought it was, right, got a false alarm, that we would not shoot a firefighter entering our property, right? And we can make that decision if we're there. But if we've loaded this gun on our garage or our front door, there is no decision, no judgment that can be exercised. And so you can't do this, quote, indirectly just because you can do it directly. Those are not the same thing, okay? And so the law allows the use of deadly force, yes, when committed in defense of habitation, property, or person, but it is narrowed so that it cannot be used unless the crime involves a more serious danger. So in fact, the court here says, even if he'd been there and confronted this burglary, he wouldn't have been justified in using deadly force. So if he wouldn't have been justified in using deadly force there, he certainly couldn't have been justified in using deadly force by use of this mechanism. Okay? So Ceballos is toast. We might be sympathetic to the impulse, right? He feels threatened, he's getting broken into, but you've got to be smarter about how you don't put people in danger who might be completely innocent and indeed first responders. This is sort of, I think, we can discuss it, but I think pretty simple, good public policy that the legislature has enacted and that the courts enforce against Ceballos. Questions about this?
I actually had a question because it talked about how there wasn't specific cases or anything dealing with it. They had to quote something from like England, and they quoted Fish and Wildlife statutes, not set trap gun. And I just didn't know why, if it was because it's so outrageous to do something like that, or
How often do you think somebody does this? Right? So you have to go to an analogous situation. That's a really good point. And to think about lawyering in this way, right? Here's these judges. And if you're a lawyer who gets a situation where there isn't much, maybe any, direct case law, you've got to find analogs from, far-flung jurisdictions. We've seen some English cases in the case book, so it's not that outrageous. Or, well, what's analogous? Well, how do we catch fish? We can either, drop a line and we are on the line, we're manually doing that ourselves, or we can set a net and go away for a few hours and see what we catch when we come back. Kind of analogous, right? So sometimes you have to be that creative and sort of get the court to think about the case the way you want them to think about it, because you may not have anything that's that, perfect case. Often that's true. Right? Sometime in your career, you will, if not more than once, you will confront a case that just comes out of nowhere. And you don't have precedent, and that's going to test how well you can be creative and think about what the case is at its core, and then be able to reach out and say, oh, it has these qualities, and those qualities are shared with this other situation. And hope the court buys it.
I don't know, in most states or in Kentucky specifically, is burglary, like if somebody breaks into your house while you're there, do you have to feel threatened by them to use the self-defense as a defense if you shoot them? Like or is
503.080.
Okay.
It says, the use of physical force by a defendant upon another is justifiable when the defendant believes that such force is immediately necessary to prevent the commission of criminal trespass or burglary in a dwelling, building, or upon real property in his possession or in the possession of another person for whose protection he acts. This is sort of one of those moments. Go to the statute. If you go to the statute, it's your first line, it's your first act. The first place you look, and it might answer your question, or at least start you on the road to answering your question.
So it said that they were armed. The fact that he had slept in there still would make it justified?
If they were armed, the fact that he had slept in there, that would make it, what the court is saying there is it wouldn't have been justified even if he had been there. So it certainly can't be justified given that he used this trap. If he actually had been there and they had been armed, then yes, it would have been justified because it would have been the more dangerous kind of felony. Okay? Okay, I'm going to give Ms. Muir the chance to say the word of the day. You almost said it, but you didn't. So here's your shot before I throw it open to everyone else.
22.
No. Oh my God, I see a million hands. Mr. Williams.
Mayhem?
No. Mr. Wiseman.
Is it string?
Is it what?
String?
No.
Automatic?
No. 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 What did you say several times?
Strap gun?
And what did you not say about that?
Oh, trigger?
No.
Mechanical?
No.
Ripwire?
Mount?
What else? What other term does the court use for that mechanism?
A machine?
Starter?
Let me make sure it's actually in there, because I'm pretty sure it is.
Oh. Just say it.
No, I'm not gonna say it.
Ms. Muir, I'm going to give it to you, because now I'm not seeing the actual words I use for it. Spring gun is correct.
It was in the footnotes.
It's in the footnotes.
Yeah.
All right.
It's in the English
I called it
statute.
footnotes.
English.
Yeah.